Good morning and welcome to the Recovery Report, where over the last 11 years here at GlobalPro, we have recovered over $1 billion for our clients. And as we always do at the first of the month, we're coming to you live from our Texas office. I'm Rob Bowlby, Regional President for GlobalPro of the state of Texas. And really appropriate this week because this past week we just had the Texas Association of Public Insurance Adjusters Conference in Fort Worth, Texas. And we're going to dedicate today's show to just kind of recapping some of the things we learned at that conference. So TAPIA, as it's known, goes on twice a year. They do a spring conference and a fall conference. This conference was located in Fort Worth this year. It moves all over the state. And it was actually our best attended conference. We had just under 100 attendees this year, including 12 new public adjusters and many vendors that had not been to TAPIA before. And it was actually really good to see a lot of the trusted vendors that we use to support our claims in attendance at the conference. And so first thing they talked about, where they gave a big shout out to the work that TAPIA does lobbying the Texas state legislature. As we talked about on this show last year, several of us went to Austin to lobby against what surplus lines carriers are doing with anti-public adjuster language. So just a little bit of a briefing here. Surplus lines carriers are carriers that aren't really admitted to do business in the state, but they can come in and do business as a surplus carrier if the insured can't find insurance somewhere else. And so what these surplus carriers are wanting to do is put a language in the policy that the insured can, for a reduced premium, agree never to hire any kind of public adjuster. We lobbied to get legislation in place to prevent that language. We did that successfully. And now Massachusetts is using that same Texas language in their own state. And we had the head of NAPIA here at the conference that said NAPIA is also reviewing that language to take it nationally to help public adjuster associations in all of the states get this same language in there. It's interesting that the insurance companies wouldn't want their policyholders to have an advocate for them to be able to help them to settle a claim fairly. And speaking on the legislative front, the big topic that kicked off the session, which may not be as well known outside of Texas, is Stonewater Roofing versus the Texas Department of Insurance. This is a case that is currently before the Texas Supreme Court that asks the question, does the requirement of licensing for a public adjuster violate the First Amendment rights of free speech of roofing contractors? And again, this case is sitting before the Texas Supreme Court. So let's go back to kind of where it started. This kind of happened back in 2003 as we had more and stronger hailstorms and more roofers started coming to Texas, going door to door and encouraging policyholders to file insurance claims to replace roofs. The insurance company successfully lobbied the Texas legislature against this, and the legislature passed legislation back in 2005 that stated that among other things, public adjusters cannot serve as contractors. So the licensing requirement was there and still remains there. In order to represent an insured in an insurance claim, you have to be one of two types of individuals. You have to be an attorney or you have to be a licensed public adjuster. And if you are a licensed public adjuster, you cannot also be a contractor that's doing work to support the claim, such as repair work, construction work, or roofing work. Again, this statute was passed in 2005, and it really wasn't passed to help public adjusters. Rather, it was passed to stop all these roofers that were saying, we'll get your claim covered, and the more we can get for the claim, the more we can charge you as a roofer. So TDI's position is merely that you cannot represent the insured when you speak to insure unless, as we mentioned, you're either an attorney or a licensed public adjuster. So it doesn't really prohibit roofers' free speech, at least in my opinion. They can say whatever they want. They can call the insurance company. They can talk about their product. They can talk about why they need the roof. But what they can't do is do it as a licensed representative for the insured, and they can't get paid for it as an agent of the insured. So Stonewater is arguing that TDI is stifling their speech by not allowing them to advertise that they can handle insurance claims and that they cannot speak to the carrier on the insured's behalf. Again, TDI is saying, you're welcome to talk to the carrier, you just can't do it as a licensed agent. And so it's interesting for those of us in the industry, we know that this goes on all the time. I mean, if you can go to several roofer websites right now and see them advertise that, yes, we will handle your insurance claim for you. And we know for a fact that roofers frequently talk to insurance companies to help handle claims for the insured. This has not been real strongly enforced by the Texas Department of Insurance. There is some attorneys out there that try to make a name for themselves suing roofers that act as public adjusters or suing contractors that act as public adjusters. But historically, TDI has had bigger things to worry about, and they haven't really focused on this. However, if this case gets a lot of attention and a lot of traction, it could kind of wake the sleeping bear and lead to a lot more enforcement against roofers and against contractors. So really what the Supreme Court is trying to decide, and there's no time frame when they'll make this decision. It could be made this week. It could be made, 3 to 6 months from now, is there a violation of free speech here? And what would happen is the lower court argued that this law does not regulate speech at all, and it dismissed the case that Stonewater brought. The Supreme Court agreed to hear it. And so if they find that it does in some way regulate speech, then that law will go back to the lower court. And likely what will happen is the law itself will be, amended or modified to incorporate things like how speech is handled, how advertising should be handled, and further define who can represent an insured. So although some people paint this as a gloom and doom that, if Stonewater wins this, then anybody could act as a public adjuster, don't really think that's the case, but it'll be interesting to follow this as it goes throughout the Supreme Court in Texas later this year. Also, we had, continuing on with the conference was 2 days, so we're still talking about the first day. We had 2 really great sessions on the practice of public adjusting itself. The first was one from Renee Sigmund. It was Myths and Misconceptions of Public Adjusters. And then Chip Merlin, who many of you know, he writes a blog. He's become kind of the policyholder's advocate. He was there to talk about Would You Hire You? And, a lot of it is stuff that we talk about a lot on this program. But, let's just kind of recap some of the reasons you want an advocate anytime you have an insurance claim. One, you want somebody that professionally they maintain their knowledge of changing insurance laws, changing construction costs and standards, and more importantly, claim handling practices. The more claims you handle, I will tell you, having done this now in my 4th year, the more claims we handle, particularly with the same carrier, we learn kind of the hot buttons of that carrier, how they handle things, who's got authority to settle a claim, how much authority do they have settle the claim. And when you work with a public adjuster, they have that knowledge of not just one carrier, but a variety of carriers. They should also know the local business building codes and ordinances. We learned about a website called One Click Code that will tell you all the building codes and ordinances for that particular municipality. One thing we often do is make sure the claim is not fraudulent. I know a lot of public adjusters get a bad rep for trying to file false claims, but really the vast majority of them do a thorough investigation of the claim to make sure the insured is not claiming anything that's fraudulent. We want to ensure that the payout is fair and an accurate reflection of the damage and coverage. We'll talk about that as it relates to appraisal and litigation here in a little bit. But the biggest part of that is communication. Just communicate often. Communicate often with the carrier, communicate often with the insured, communicate often with all the parties involved in the claim. If you have a significant size insurance claim, even on a small insurance claim, you generally have a lot of parties. You may have a pack-out company. You may have a mitigation company. You may have a contractor. You may have subcontractors for things like HVAC cleaning and electrical testing. All of those people need coordination, and that's one of the most important roles of the public adjuster. One thing that most policyholders don't do that you want a public adjuster for is to read the policy. It's the first thing we look at. The first thing we do is request that certified copy of the policy from the carrier to make sure that we understand all of the coverages and that we have all of the endorsements and amendments that the insured may not have if they're just looking at their most recent renewal. Talked about the CLUE system. The CLUE system is a claims reporting system that all the carriers use. It's run by LexisNexis, but we get that question a lot. If I file an insurance claim, how long does that stay on my record? That is for 7 years is what the CLUE system tracks back. And again, all carriers can pull that by insured. They can pull that by property. They can see what claims have been filed. Our role is to help the insured prove the claim is covered under a covered peril and loss under the policy. And, one of the big things that is common sense, but they say it a lot, is don't lose control of your emotions. Dealing with insurance carriers can be very frustrating. The role of the public adjuster is to be firm, to be direct, but also be that calming professional voice to say, hey, all we're trying to do here is the right thing for your insured. We want to be fair to you, the carrier. We want to be fair to the insured and settle this claim so that the insured can restore their property to pre-loss condition. That led into another hot topic called the appraisal process. And there was just a couple takeaways from this. So just to recap, we've talked about it on this program before, but if you can't reach agreement with the carrier, there's a process you use called appraisal, where the insured hires their appraisal, the insurance company hires their appraiser, and those two appraisers meet and agree on the amount of damage. A big part of the problems with this process is, one, the timing of it. Although there's guidelines as to when the appraisers have to be picked and when the two appraisers have to agree on a third party called the umpire, who will make a ruling if the two appraisers can't agree. Once you get beyond those agreed upon timeframes of choosing appraisers and choosing umpires, there's no well-defined clock. And we've seen appraisals on simple claims take 3 to 4 months. On complex claims, they can take longer than a year. And so that's one of the problems with the process, is it lengthens out the claim process for the insured, during which time they should not, and in many times cannot, repair the property because they don't know what they're going to have proceeds-wise to do the repair. So one of the biggest problems is just finding some kind of format to put some time frames in there that says, something like, unless it's unusually complex, you should be able to get an appraisal award back in some time frame, whether that's 30 days, 60 days, 90 days, just some time frame that starts a clock ticking for both parties' appraisals so that you can get that information in a timely manner. And Steve Badger, who's a lobbyist and an attorney for many of the insurance carriers and is well known in the industry, he was there to provide a counterpoint. And Steve's a really articulate and thoughtful individual, made some really good points, and it was a really civil discussion. But one thing he brought up, which I'm in 100% agreement with, is many adjusters are using appraisal as an alternative to actually adjusting the loss. And I think every public adjuster in that room agreed that appraisal should be kind of not a last resort, but should be late in the process after you've exhausted efforts with your carrier to adjust the claim by the public adjuster preparing their own estimate, supporting it with the proper scope document with proper documentation to support that scope, and arguing that with the carrier. But what we see sometimes is there are what I would call a bad public adjuster that signs up a claim and then just kicks it immediately to appraisal. So appraisal should be rare, and it should be used to determine when or what the amount of damage is. So one of the things that occurred in the panel is they had a kind of a Q&A as to whether under Texas law, appraisal should be used to handle these types of disputes. And so I'm going to run through these real quick. Disputes as to the cost of repair and necessary scope of repair of damage. Yes, that is 100% proper use of appraisal and should be the majority of the use of appraisal when you've already kind of agreed on part or all of the scope, and you're just arguing over what does it really cost to repair this damage. Dispute as to whether there is any damage at all. It depends. This can be used, appraisal can be used here, but that's a really gray area. Dispute as to when the damage occurred, no. That is a policy question and should not be handled by appraisal. Agreeing on whether or not the damage is cosmetic, yes. That is a proper use of appraisal, but only if there is a question as to when the damage occurs. And also going back to cosmetic, there's more and more riders coming out that says cosmetic damage is not covered. One of the things one of the attorneys raised was, unless the policyholder has signed something, this is an old Texas statute bulletin that came out, unless the policyholder has signed something agreeing to a reduced premium for this cosmetic endorsement, then it's not really enforceable. So that's something we'll be on the lookout for as we see more and more roofing claims. Whether or not code upgrade coverage applies, this is usually a coverage issue. Appraisers can value the code upgrade and put it as a separate line item, but let the two parties agree on whether the coverage is there. So you may have to repair undamaged property or do things to part of the property that's not damaged in order to comply with comply with building code if it's the type of loss that's going to be required to be inspected by a building inspector. But in order for those costs to be covered by the policy, you have to have code coverage language in the policy. So just a really good session on appraisal. Lots of good back and forth between the public adjusters and the appraisers. And then finally, two other sessions that were really interesting. One was the use of artificial intelligence in the claims process. So, in my opinion, there's good roles and bad roles for that. Some of the good roles is it is a good way to kind of use algorithms to track down fraud and to say, should we dig a little deeper? Completely good with that. A little more concerning is these drone inspections. You'll have claims get denied or policies not be renewed because a carrier did a drone inspection. That's really interesting that they didn't send a human out to have that discussion with you. We've got some issues with that. And then, I think it's just going to be a long time before an insurance claim could or should be adjusted without any kind of human interaction. So particularly if you ever, and we're probably not that long from carriers trying to make insurance adjustments by artificial intelligence, but if you're an insured and on the other side of that, that's even more reason for you to hire a public adjuster as your advocate. And then the final session was on OSHA guidance. Kevin Dandridge was there. He is an expert in OSHA and feels like it is frequently left off not only of job sites, but frequently left off of insurance estimates. And one of the reasons it's left off of job sites is because the insurance carriers aren't paying for the equipment and the safety protocols. So really informative session, something for us to take into consideration as we do estimates going forward, because every reconstruction is a job site and every job site has OSHA requirements. Different job sites have different levels of life safety requirements, but all of them have some. And so that's something we're going to be discussing with Kevin to make sure we have all of that properly documented in our estimates. There's lots more I could talk about, but just wanted to give a brief recap today. If you're in Texas, if you're in the industry in any way, whether you're a public adjuster, whether you're a mitigation company, a contractor, somebody that works with public adjusters, I highly encourage you to join TAPIA, the Texas Association of Public Insurance Adjusters, and attend the spring conference. That's it for today's recovery report. We'll see you next month from Texas.